Hi, my name is Kimberly and welcome back to my channel. We talk about all things parenting, all things divorce, and some other different legal topics if you subscribe. If you haven't subscribed yet, please be sure to subscribe down below if these are the kind of videos that are of interest to you. Today's topic is mediation, and I am going to talk to you about the 5 benefits of mediation. If you've been court ordered to go to mediation, and even if you haven't and your attorney has just kind of suggested it to you, the first thing you need to know is, what is mediation? Mediation is not arbitration, but it is an alternative or different form of dispute resolution. You meet with the mediator in a neutral environment, and the mediator is not biased. They work through your case with you. They help you figure out the best solution or a solution that you can live with to avoid going to court and get a resolution to your case. The first benefit of mediation is that it is much faster than contested litigation at the courthouse. Dockets are really full, and sometimes the attorney on the other side is slow walking your case. It can take months or even years to resolve your case. Mediation can resolve your case in 1 or 2 days with 1 or 2 meetings. Most mediations for divorce and parenting time take less than a day. The second benefit of going to mediation is that it is much cheaper than contested litigation. You're not having to pay for court reporters and expert witnesses and having your attorney and the other attorney prepare for trial with witnesses and exhibit lists and all the things that go into contested litigation. You are paying your attorney and the mediator for the day. And usually you can get most of your case, if not all of it, resolved in 1 day at a much cheaper cost. The third benefit of going to mediation instead of contested litigation is that it is private and confidential. Everything you tell your mediator in a private session, not a joint session, but everything you tell your mediator in a private session is private. It's confidential. Also, whatever agreement you reach at mediation is confidential. You're not sitting in the courthouse where people can come in and out of the courtroom and hear everything that's on the record. You are in a private situation with a confidential mediator, and you actually normally sign something in the agreement to mediate that says everything that you talk about is confidential. Another thing that you need to realize is that your mediator cannot be called as a witness against you at trial in most circumstances. So if for some reason you don't settle, you don't need to worry about having the things that you talked about at mediation spread into the courtroom or to contested litigation. The fourth benefit of going to mediation is that the parties, that's you, are much more likely to stick to the agreement when they have some input and say into what's in the agreement. When you go to court, the judge may give you something that both parties don't like. So if you have some input and you're weighing the things that you're willing to give up, and you're also talking to your attorney and the mediator about the things you definitely need to have to reach a settlement, you are much more likely to stick to that agreement and abide by the terms of that agreement if you've had some input into the agreement. The fifth and final amazing benefit of mediation is that if you reach an agreement at mediation, let's say about your parenting time, you can actually start that mediated agreement today. Meaning that if you don't have a court date until November or December and it's September, you can go ahead and decide who gets fall break, where the kids will be at Thanksgiving, who's going to pay for different things like extracurricular activities and things like that. So you can go ahead and start your mediated agreement the same day that you finish mediating it. Of course, you do need to get the judge to sign off on all the paperwork at your court date, which normally can be obtained pretty quickly because you're not going to be there very long. You just need to hand off some documents. The judge will look through them and sign them. Sometimes they may make minor adjustments or have a few questions, but most of the time, a mediated agreement is enforceable and it is put into the record and your case can be closed out. One final thing that I would like to bring to your attention is that if you live in the state of Tennessee, the Tennessee Supreme Court has provided a state listing of all the mediators that have gone through state-approved training. I'm going to put a link to how you can find one of those mediators in the description box below, so you can click on that and see if the mediator that you have chosen is one of those trained mediators under a rule in Tennessee called Rule 31. So you may also want to ask your attorney the question, hey, is my mediator a Rule 31 listed mediator? Are they on the state list of mediators that have received Tennessee Supreme Court Rule 31 training? Thank you for watching my video today on the 5 amazing benefits of mediation. If you are court-ordered to mediation, and even if you're not, I hope that you go into mediation with an open mind and that you can get your case resolved as soon as possible. If you liked this video, then please give it a thumbs up, subscribe down below, click that notification bell, and then you will be notified every time we make more videos like these.